Hello, everybody. Welcome to Business Bites. My name is Henry. I'm here on behalf of the Kent and Victor Chamber of Commerce. Today, we are absolutely delighted to be joined by Colin Smith and Melissa Nelson from Chamber Patron Members Brachers, who will be delivering this Business Bites webinar on sexual harassment. Before we do kick things off, if you do have any questions throughout the session, please drop those into the chat, and then we will have a dedicated Q&A at the end where Colin and Melissa will be able to answer your questions. So I'm now going to pass you over to Colin and Melissa.
Thank you, Henry, and good afternoon to everybody. Welcome to today's short review of the new rules on sexual harassment. If you don't know me, if you haven't been to any of our other webinars that I've done, my name's Colin Smith. I'm a solicitor at Brachers. I'm accompanied today by my colleague Melissa Nelson, who is doing her first webinar. So please be kind, because she's understandably a little nervous at doing her first live webinar, and they are rather different to doing live presentations. But we'll stop prattling in the introduction, as I have a habit of doing, and get on with today's content, because we have a limited amount of time, and if there are questions at the end, we do want to make sure we've got some time to try and get through them. So welcome. That's who we are. That's our details if you need them. We have a website and everything else. Feel free to have a look if you don't know who we are and why we know what we're talking about. Okay. Melissa's going to go through the initial part of today's session, and then I'm going to talk about the new duty and what it means and what we understand you're supposed to be doing. Okay, so I'll hand over to Melissa for the first part of today.
Thank you, Colin. So before looking at the new duty, I think it's helpful to be clear what we actually mean by sexual harassment. So sexual harassment is unwanted conduct of a sexual nature which has the purpose or effect of violating an employee's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment for the employee. So conduct of a sexual nature, what does that mean? Well, it includes a wide range of behaviour, such as propositions and sexual advances, unwelcome physical contact, sexual comments or jokes, displaying pornographic drawings, or sending emails or messages that have material of a sexual nature. And it's important to recognise that sexual harassment is initially judged from the victim's perspective. So they will be protected unless their reaction is unreasonable in all the circumstances. So to give a basic example, if an employee routinely shares jokes of a sexual nature, or perhaps makes comments that are a bit close to the line, but then feels very aggrieved when a sexual comment is perhaps aimed at them, then it may be that if that claim made its way all the way to a tribunal, a judge might find that actually that reaction was unreasonable in the circumstances. But obviously worth bearing in mind that these cases are all very fact specific. So an individual can experience unwanted conduct from someone of the same or a different sex, and also sexual harassment can be perpetrated or experienced by men or women, but the figures do tend to show that women more often are the target of behaviour by men. So is it a big problem? Well, many employers don't consider sexual harassment is a problem for them. However, the figures do suggest otherwise. So as you'll see from the survey in 2023, Trade Union Congress had a survey done, and actually 3 in 5 women had experienced sexual harassment at work. Only 1 in 3 had actually reported it to their employer. Slightly more dated survey in 2020, Government Equalities Office, they had over 12,000 individuals interviewed, and 29% of those in employment had experienced sexual harassment at work in the previous 12 months, and only 15% of those who had suffered had reported it. So what is clear from the figures is that underreporting is a big issue. Some of the barriers to underreporting can include a view that the employer would not take the matter seriously, a belief that the alleged harasser might be protected, particularly if they are a senior member of staff, fear of victimisation, and a lack of appropriate reporting procedures. So it shows that even if you don't have a history of sexual harassment in your organisation, you haven't had any complaints or claims, It may be that there is an issue and it's just not being reported. So why is it important to address it? Well, harassment at work has a significant negative impact all round. You have the damage to mental and physical health of the individuals themselves, which can affect their personal and working life. And then there's risks to a business as well. Economic costs are harder to estimate. However, there was an incident in 2018 where Ted Baker announced it was going to have to investigate claims of inappropriate behaviour against its founder, and the share price literally dropped by 15%. There's also Harrods in the press at the moment with sexual abuse allegations being made against the late owner, Mohammed Al Fayed. And obviously, again, no business wants to be in the press for those sorts of reasons, so it can then damage customer relations as well. There can also be an impact on retention and recruitment. And in 2018, there was a worldwide walkout at Google's offices because of how they had handled allegations against senior members of staff there. So yes, it is important really to address any issues of sexual harassment in the workplace. So what's the current position before we look at the new duty? So individuals can already bring claims of sexual harassment under the provisions of the Equality Act, and an employee can bring a claim against both the perpetrator and their employer. Now, the employer can be vicariously liable for acts of its employees, and the only way of avoiding that liability would be if the employer could show it took all reasonable steps to prevent the harassment from occurring. So obviously all reasonable steps is quite a high hurdle to overcome. And the current position differs really from that we're about to look at, because it's quite a reactive position, whereas the new duty places additional responsibilities on employers to try and proactively prevent sexual harassment from occurring in the first place, rather than waiting for something to happen and then looking to address it. So Colin is now going to look at the new duty.
I mean, hopefully that gives a flavour as to why we have this new duty, because we deal with a lot of employers who will tell you, quite rightly, they don't have a sexual harassment issue. They don't have claims. They don't have people suing them for it. But the evidence is that most businesses will have some form of sexual harassment within them. That's what statistics tell us, even if it hasn't bubbled to the surface to the point where you're dealing with a claim. Okay? And that's the stark reality check for everybody. Our own business, we will probably have examples of this somewhere. The statistics tell you that, unfortunately. Okay, and that's why we have this new duty focused specifically on sexual harassment, is to try and tackle that underlying, ongoing, still present in 2024 problem. Okay, so what we have is a new legal duty, and to go with it, we have a new technical set of guidance from the Equality and Human Rights Commission that underpins it. Okay. If you want to go and read the guidance, you really ought to go and read the guidance if you're here today, because this is something you're having to deal with. Go and read the guidance. It has been inserted into their wider technical guidance from 2020, but it's been inserted in as a section called the preventative duty. It's around 3.12 or 3.13 if where it all begins, but it's in the slides. We will be sharing the slides, so you'll have access to all this. You don't have to follow it all as we go through. We've paraphrased some of the guidance under the relevant sections we're going to deal with, but the full guidance is all there on the Equality and Human Rights site, and it is important you go and read it because it has far more detailed examples and even more detail than we're going to be able to summarise today. Okay, so if you're going to deal with this, go and read it, because it will give you the depth of detail that we can't go through today. Okay, key points comes into force on the 26th of October, not very far off now. We are 1st of October, I believe, today. So you've got 25 days to sort this all out if you haven't done anything yet. It's a mandatory duty. The duty is to take reasonable steps, not all reasonable steps, but reasonable steps to prevent sexual harassment in the course of their employment. The bits in italics for the paragraph numbers are taken from the guidance. Okay, So that's what the guidance says. It reinforces what we've just said. You must take reasonable steps to prevent sexual harassment of workers in the course of their employment. That's the new duty in summary. Okay. It is, as Melissa pointed out, anticipatory. In other words, it's a prevention duty. You are meant to take these steps in order to prevent sexual harassment happening in the first place. Okay, that is the standard. You should not wait until you have an issue to then take steps to prevent an issue reoccurring. You should take steps to prevent an issue occurring in the first place. Okay, and that means you have to sit down and think about where and how and why sexual harassment could occur in your workplace. And we'll come on to that in a bit more detail in a minute. Okay, it's not wait and see and then deal. It's try to stop it ever being a problem to begin with by thinking ahead. Okay, but it is a duty to prevent only sexual harassment. It is entirely specifically focused on sexual harassment, not even sexist harassment, or for that matter, racial harassment, disability related harassment, age related harassment, pregnancy related harassment, etc. Okay, it is very specific. It is purely to prevent sexual harassment. And that is the pure focus. It's a bit odd in that sense why sexual harassment gets such special treatment over, say, racial harassment. Not for me to say, but that's what we have. That's what the duty is focused on for now. Whether it will extend in due course to other forms of harassment or other protected characteristics, I suspect it might. We will see. Okay, but it's purely sexual harassment, and the Equality and Human Rights Commission's guidance also acknowledges that that is its limit. Okay. Third parties, this is where it gets a bit complicated. Originally, going back a couple of years, there were proposals to extend the Equality Act to apply to discriminatory activity by third parties. Okay. And it's gone back and forth over the years whether you can be responsible for the discriminatory acts of third parties rather than just your employees and your agents. Okay. And where it's landed and where it will remain is that you can't be technically liable for the actions of third parties for now. Okay, but where it gets a bit odd is that the EHRC guidance says that they can take enforcement action against you where discrimination has been committed by third parties if you haven't complied with your preventative duty, this new duty to prevent harassment by people, including third parties. Okay, so in theory, your employee can't sue you because a third party discriminated against them. The EHRC can find out about it and come and take enforcement action against you. How likely that is a different question, but in theory, that's what can happen. Okay, so you do have to look at this from the point of view of preventing harassment, not only by your own staff and your own contractors and your own agents, but also by third parties, i.e. the general public, against your staff, which makes it quite a broader duty than historically has been the case. Okay. So the EHRC recommends including steps to tackle third-party harassment, possibly putting up notices saying that harassment will not be tolerated. Are you going to end up with a sign in the reception or next to no smoking sign saying do not harass our staff, or specifically do not sexually harass our staff? Seems a bit bizarre, but that's the kind of step that the guidance is contemplating you ought to be considering. Okay, should you be putting provisions in contracts with third parties about complying with anti-sexual harassment provisions, okay, or codes of conduct for people coming onto your premises? How practical is any of this? But these are the sorts of things you need to start thinking about. And how do you encourage and facilitate your own employees to report sexual harassment against them by third parties? Okay, so you've got all these elements to consider. And I won't go through all of the wording from the guidance, but again, it's all reiterated in the various paragraphs of the guidance that are in the slides that you can read through when you've got your own time to do so, as it were. Yeah. And as we say, it's all primarily going to be enforced by the Equality and Human Rights Commission. They will have enforcement powers, they will have investigation powers. In theory, where an employee can bring a claim for discrimination and you haven't complied with the preventative duty, they can be awarded an additional up to 25% on any damages they get. Bearing in mind that discrimination damages are in theory unlimited and uncapped. That could be a little or it could be a lot. Okay, so an extra 25% for not complying with this duty could add to your woes if you're found guilty of discrimination in court particularly sexual harassment discrimination. In this case, you could be looking at a further 25%. Okay, but they can't bring a standalone claim, an employee cannot, for breaching this duty. Okay, they can bring a sexual harassment claim and get extra money if you didn't comply with the duty, but they can't bring a standalone claim for not complying with the duty. Okay, the Equality and Human Rights Commission may, however, come after you with their wider powers. Query, they may have quite a lot to do for the next few years yet, say, with trying to enforce this duty. So again, I won't go through all the sort of different slides with the italics because I'm conscious of time and trying to give time for questions at the end. And I want to get on to the more interesting stuff, which is the duty is to take reasonable steps to prevent sexual harassment. So what are reasonable steps? Unfortunately, there is no one-size-fits-all list of reasonable steps. If you tick the boxes, you are safe. It's not how it's going to work. Okay. What is reasonable according to the guidance and the law? What is reasonable will depend on all the circumstances, including the size of you as the employer, the resources you have as an employer, the sector or the industry that you work in, and the working environment that you have. In other words, some sectors and some working environments are considered to be higher risk than others. Okay, therefore, what's reasonable is likely to require greater steps than in other environments. The bigger you are, the more resources you've got, the more you will be expected to have done, I'm afraid. Okay, that's just as clear as we can make it. So to put that in context, what could be reasonable? Well, as we say, you look at the size, the nature, the sector, the risks, the nature of any contact with third parties, the types of third parties, the frequency of those contacts, the environment. You also look at the likely effect of taking a particular step and whether alternative steps could be taken. It's all unfortunately rather generic and not particularly specific, but you look at the time, cost and potential disruption of taking a particular step and you weigh that against the benefit it could achieve. Okay, you look at whether or not you've had issues in the past with harassment. You look at whether you've got a history of harassment, in which case the steps you're expected to take are likely to be higher or more detailed than they are if you have no such history. Okay, you have to consider whether or not you've got wider regulatory standards, for example, that we would have. Okay, and you have to look at whether or not the steps you've taken in the past have actually worked. In other words, there is no point saying we've taken reasonable steps by repeating the steps we took in the past, even though that didn't prevent harassment. Okay, whereas I think Einstein once put it, you know, the definition of insanity is doing the same thing over and over again and expecting a different result. Yeah, so if you keep taking the same steps and not getting a successful outcome, you're not going to be able to defend yourself. So what's reasonable is unfortunately quite broad, but if you read the guidance, it does give you more specific examples of the sorts of steps you might be able to take. But the one thing that it majors on, and the one thing that you need to therefore have documented and done, is risk assessment. Okay, and that's why we want to have a look at that in a bit more detail. So the major concept of the new duty is risk assessment. Okay, and what the guidance says is an employer should consider the risks of sexual harassment occurring, consider what steps it should take to reduce those risks, consider what it's reasonable to do, and then implement those reasonable steps. In other words, do a risk assessment, come up with an action plan, and then implement that action plan, and then review and monitor the success of that action plan. Okay, as well as have somebody designated, most likely, who is responsible for all of that. Okay. And critically, it says an employer is unlikely to be able to comply with the duty unless they've carried out a risk assessment. So it's considered a pretty fundamental step in meeting the preventative duty, is doing this risk assessment, looking at where you have risks of sexual harassment in your organisation, identifying the higher risk areas, identifying the steps you're going to put in place to tackle those, implementing those, and then reviewing over time whether or not those steps are proving to be successful. Okay. So it says employers should make an assessment of risks relating to harassment, sexual harassment, and victimization. Existing risk management frameworks can traditionally be used. This is almost similar to health and safety type risk assessments, not quite the same, but it's that sort of territory. Okay. And you should identify the risks and the control measures identified to minimize the risk. So again, it's that health and safety idea, if you do a risk assessment, you identify the risks, you identify the measures you're putting in place to mitigate or reduce or avoid those risks. Okay, so what makes a workplace a risk? And this is where it gets a bit controversial. So what the guidance says in terms of, well, how do I identify whether my workplace is a risk or a high risk or a medium risk or a low risk, and therefore needs high level mitigation measures, medium mitigation measures, or minimal mitigation measures? Yep. Well, power imbalances, particularly men over women, unfortunately. Sorry for all the men on the call, but we are statistically the main perpetrators, men in positions of power, younger women primarily in positions not of power. That is still, even in 2024, where we consistently see sexual harassment occurring. It's not all men, I appreciate, but it is unfortunately a higher risk scenario, where you have got workers with job insecurity, therefore more likely to be unable to speak out or speak up. That is considered to be higher risk. Lone working and night working, for obvious reasons, opportunity, unfortunately. Presence of alcohol, working environments where, let's say, the boundaries between social and professional are more easily blurred. Hospitality, pubs, restaurants, hotels, they're unfortunately, more likely environments for this sort of behaviour. Whether people have customer facing duties and are likely to be subject to harassment by customers. I won't go through them all, but it just gives you an idea of the risk factors they expect you to assess against your own business. And those factors may vary in different parts of your business in different locations. Okay. Socializing outside of work can be a risk factor. Okay, and as can the demographic of your workforce. Unfortunately, predominantly male workforces, evidence tends to indicate, may have a higher risk of sexual harassment. The fire services across the country are currently facing some pushback, let's say, and some challenge in a very male-dominated environment still about these sorts of issues. Okay. And again, there are certain factors, again, that may increase the risk, and they're very similar, but these, again, are repeated in the guidance. So male-dominated workforce is unfortunately considered to be a risk. A workplace culture that permits crude or sexist banter or other disrespectful behaviour is considered to be a higher risk, as it were. Gender power imbalances again, alcohol again, social events and conferences again, etc. I won't go through them all, they're all in the slides, but these give you the sorts of factors to judge your own business's risk against when carrying out a risk assessment. Okay. And just because the risks might only affect one person doesn't mean you can ignore them. Okay, there's not a threshold if it has to be a risk that affects a minimum number of people. Okay, so you're going to have to look at the composition of your workforce. You're going to have to look at the physical environment in which they work. You're going to have to look at the history of whether or not you have had issues with sexism or sexual harassment. You're going to have to look at your policies. You're going to have to look at your training, and you have to come up with an action plan of steps that you are going to take, either across the whole of the business or targeted to the risk areas of the business, which can be tricky and controversial in itself. But this is what you're supposed to be doing to meet this preventative duty. And then you're supposed to be reviewing it on a regular basis. Okay. And as we say, you should specifically assess the risk in the course of employment. You should do that, review that regularly, and then put in place mitigating actions. Okay. But you're unlikely to be able to defend yourself if you haven't done all of these steps, I'm afraid. Policies, very briefly. The key bit on policies is, again, please read the guidance on what it says about policies, but it's a key plank of compliance. They should set out the things that are noted on the slide. I won't go through them all, and you should review the policy regularly. What is a bit clearer from this guidance is that they do expect you to have a specific policy for sexual harassment and specific guidance and rules on sexual harassment, not just general harassment rules. Now, they don't go as far as saying it absolutely has to be a standalone sexual harassment policy or a standalone sexual harassment rules, but at the very least, it has to be almost a standalone section within your wider anti-harassment or dignity at work type policies and procedures. So if sexual harassment currently gets one line, it should be getting its whole section going forward, at the very least, in your policies and procedures, possibly its own policy, although that still to me seems a bit odd as to why sexual harassment gets its own policy over other forms of harassment. Okay, but it should be almost set out on its own as a specific item to tick these boxes. Okay. And you may want to consider, may, not must, may want to consider appointing a designated lead who is responsible for your risk assessment, your action plan, your reviewing this. You have, unfortunately, the health and safety person for sexual harassment, almost, if you know what I mean. Yeah. The person who's taking the lead and responsibility for this. Okay. I won't go through all of this because you can read some of the guidance paragraphs at your own leisure. Okay, but this is where it makes the point that you should have specific provisions to deal with sexual harassment, or at least in a policy that clearly distinguishes the different forms of harassment. Okay. And interestingly, it does say when coming up with anti-harassment policies, you should develop them in consultation with recognised trade unions if you have them, or if you don't have them, other worker representatives. I don't know how many organisations get employee representative input into the development of anti-harassment policies. That would be quite a radical change, okay? But it is something recommended as part of meeting this duty, okay? So do you have a policy? You should hopefully have anti-harassment and anti-discrimination policies. If you don't, you now need them even more so, but you needed them anyway, okay? But also, what are you going to do in respect of contractors, visitors, customers? How are you going to make them aware of your standards, of your expectations, of your rules? Are you going to require certain contractors who come and spend time on your site to undergo your own training? Are you going to expect them to sign up to some kind of commitment on anti-sexual harassment? Yeah. Are you going to put clauses in the contracts saying they will not behave in this way? These are all things you need to think about as part of this preventative duty. Okay, there are no hard and fast rules on how to do this, and we're still obviously finding our way with new rules, but these are all the sorts of considerations you need to think about. Training, fairly obvious, it's a part of the preventative duty. Training and awareness, obviously giving specific training to staff and also to managers on how to identify and intervene with situations of sexual harassment. Okay. I won't go into more detail than that, but other than, yes, you need to do training. Yes, you need to repeat that training regularly. And yes, it obviously needs to be quality, detailed training, not just tick box 10-minute online course on sexual harassment. That probably won't fly, I'm afraid. And then reporting, the last bit is reporting and culture, which is you are supposed to be trying to create a workplace culture with a zero tolerance to sexual harassment that encourages and enables the reporting of sexual harassment. Okay, how are you going to do that? Is your grievance procedure sufficient to do that on its own these days? Do you have separate whistleblowing type hotlines? Do you have separate arrangements through which people can bring sexual harassment to the table? Do you decide to have a separate reporting route for sexual harassment over your normal grievance type procedures? It's not saying you have to, but obviously the more you do, the better you'll be from a preventative duty point of view. But you have to balance that against the cost and the hassle and the resources that you have to deliver all of that. Okay. That was a very whistle-stop tour, but to summarise, you've got until the 26th of October to put some steps in place, or don't, and then hope you don't end up with a claim or the EHRC asking you what steps you've done. The latter one's probably unlikely unless you're McDonald's or Pizza Hut or in the headlines for whatever reason, but because their resources are limited. But if you do get a sexual harassment claim by an employee, it will cost you more if you haven't done these things, okay? And as Melissa said, it's not just about the 25% uplift, it's about the wider damage, the wider reputational risk, the wider harm to your recruitment, your retention, all these other issues that come out of sexual harassment in the workplace, okay? But you do need to do these risk assessments, you do need to come up with these action plans, you do need to implement training or refresh training if you haven't done it for a while, and you do need to give your policies a review, a refresh, and most likely beef up the provisions that you've got on sexual harassment from what they are now, because most policies and procedures probably don't do as much as this guidance is recommending. And that was a very fast run through of what is quite a lot of detailed guidance. As we say, we've put links in the slides to the guidance. Go and read it. It's got a lot more detailed examples in it of particular scenarios of what they might expect you to have done as an organisation to comply with this duty. Okay, but it is risk assess, train, action plan, review, key commitment from senior management, culturally making sure that there is buy-in to a no sexual harassment environment, and looking at whether or not you have sufficient channels through which people can be encouraged to come forward and raise concerns, which is the trickiest bit, as Melissa said. I can't remember what the percentages were, but let's say a much higher percentage reported experiencing sexual harassment than admitted to coming forward and raising it, which tells you if no one in your organisation is raising it, there is a chance that it's still going on, just people don't feel enabled to come forward and say so.
Perfect, fantastic. Thank you very much, Colin and Melissa, for that really informative whistle-stop tour of what you said quite clearly is a lot more information. So we do have a bit of time. Does anybody have any questions at all that they'd like to ask Colin and Melissa specifically about this or anything in particular related? Feel free to unmute and ask if you do. Like Melissa and Colin said, we will be able to share the slides afterwards, as well as the recording, which does have their contact details on there if there are any particular questions that you want to specifically ask them that perhaps you're not comfortable asking in front of the audience. That's absolutely fine. Perfect. I don't think it looks like we do have any questions at all. So again, I'd just like to reiterate our thanks here at the Chamber to our valued patron members Brachers, specifically Colin and Melissa, for that presentation. Thank you to all of you for coming and joining and taking time out of your day to listen and learn a bit more about what is happening on the 26th of October and the new rules. If you did have any questions, contact details were in the slides, which will be sent out shortly after the event has finished. And other than that, I hope you all have a great rest of your day and thank you very much for coming. Take care.
Thank you all.
Thank you.